You have cited quite a number of very impactful cases during your tenure. Are there others that perhaps have had significant impact on Caribbean civilization?
We had a case from Barbados, Gibson, which was very interesting. A lady turned up, she was murdered, and police got a little bit of information. They arrested this man, and they found nothing to link him with the crime. But they got a dentist to look at him, and the dentist said, that bruise you have on your biceps, that is a bite mark. The dentist went to the morgue, took measurements of the deceased's oral cavity, and concluded that only the deceased could have made that bite mark. And on the strength of that, that's the only evidence that the state had to charge this man for murder, and they charged him with murder. The man said, I'm innocent. That bite mark, that is not a bite mark. I got that from a bruise. I was climbing a guava tree and I fell or something. And he was being charged for murder. So the man said, he had a good lawyer, that I need assistance from the state, because I'm a poor man, to retain a forensic odontologist who can assist in proving my innocence. Now, bear in mind, he has no constitutional obligation to prove his innocence. But if the state is saying to you, here is a dentist who says that only deceased could have made that fresh bruise on your hand, and it is a bite mark from the deceased, then he certainly needs to be able to disprove that. The long and short of it is that it came up to us because there was an issue as to whether the state was required to give him money in order to prove his innocence. And we took the view that yes, in these circumstances, the trial could not be fair if in an esoteric field like forensic odontology, which is the study of bite marks, you present a dentist who's not a forensic odontologist, and you are trying to get a jury to convict him on that basis, and he lacks the ability to be able to disprove or to contend with what you're saying. And as it turned out, the state, well, we ordered the state to do one of two things: either to drop the charge or to provide the man with the services of a forensic odontologist. Forensic odontology is the study of bite marks. And that bite mark evidence is notoriously suspect. It's not like DNA or like fingerprint. It is very subjective, very unreliable. And at the end of the day, the state got their own forensic odontologist who told them that that dentist's best efforts were not very reliable, and that they really did not have the kind of evidence that they needed, and so they chose to drop the case. But issues like that demonstrate the value of a CCJ, because that man could not have afforded to go to the Privy Council if Barbados still had the Privy Council. And here you have a decision that not only has allowed him to get justice at the highest level, but has also expanded the definition of what it means to have a fair trial, so that the reasoning in the case doesn't just relate to his own evidence, his own circumstance with bite mark evidence. It also speaks to the definition of a fair trial and is of value to many litigants in years to come.
Justice Saunders, we know the value of having the CCJ. There's the cost of affordable justice at the highest level. There's the fair trial issue, and of course, the fact that the decisions are relevant to Caribbean people. How difficult is it for local courts who have always taken their matters to the Privy Council to transition to the CCJ?
Well, the local courts really don't have much of a, there's not much that they can do. This is a political issue. It is for governments and very often for opposition parties as well, because invariably transitioning to the CCJ on, I don't have misinterpreting your question, but let me deal with this first. Transitioning to the CCJ, embracing the CCJ invariably requires an alteration of the Constitution. And because you're dealing with a very sensitive part of the Constitution, justice, the Constitution has built-in guardrails to protect those provisions that you're trying to tamper with. And the way those guardrails express themselves is that you require a qualified majority, 2/3, sometimes 3/4 in the parliament in order to effect that change in Constitution. In Grenada and Antigua, you must go to a referendum. And not only must you go to a referendum, but you must get 2/3 majority at that referendum. In St. Lucia, St. Vincent and the Grenadines, Dominica, St. Kitts and Nevis, mercifully, there is an alternative to going that referendum route, where you just go to the parliament and get a 2/3 majority. In Dominica and in St. Kitts and in St. Lucia, the governments had at least a 2/3 majority in parliament, and so they did not require the support of the opposition in order to effect the constitutional change. So they could do it on their own. In St. Vincent and the Grenadines, I can't recall exactly what the position is in St. Kitts and Nevis now, but you need the support of the opposition. And therefore, if you don't get that support, you can't. So that is one thing. In terms of the questions you asked, courts transitioning, the Eastern Caribbean Supreme Court now has a very, not overly difficult, but an awkward situation to deal with, because that is a court that serves 3 British overseas territories and 6 independent territories. So let's deal with the 6 independent territories, because these are independent territories. 2 of them now have the CCJ as their final appellate court. 4 of them have the Privy Council as their final appellate court. Increasingly, it's beginning as a little fissure, first of all, and then that fissure is slightly widening. You have a divergence between the jurisprudence of the Caribbean Court of Justice and that of the Privy Council. Nothing great as yet, but increasingly there is going to be differences in how we perceive things, because of course they're perceiving it from across the Atlantic, we're perceiving it from here in the Caribbean. On the issue of something that is called the Savings Clause, that is a clause in the constitutions of Caribbean countries that pretty much says all the laws that were passed during the colonial period are not to be held to be inconsistent with the Constitution, so that those laws must remain in place until and unless the local legislature, the local parliament revises them, annuls them, modifies them, disables them as a case. And that was part of the issue in Guyana, because those two cases that I spoke about, the cross-dressing one and the one about the DPP, the local parliament had never done anything about those laws. And one of the arguments that was made to support leaving the law intact was that the Savings Law Clause protects those laws from being held unconstitutional. Well, the Privy Council has gone on record, and they have, in the words of Americans, doubled down on what they have done in saying that the Savings Law Clause is sacrosanct, that you must allow colonial laws to operate in their pristine form unless Parliament has changed them. The CCJ would have none of that. The CCJ has gone on record as saying that the Savings Clause, any colonial law which is inconsistent with the Constitution, must be modified to become consistent with the Constitution. So to get back to the point is that you have the Eastern Caribbean Court of Appeal that is now going to be faced with principles and jurisprudence from the CCJ that persuades it, influences it to go in one direction, and jurisprudence from the Privy Council that seeks to persuade it to go in a different direction. That is very awkward, very, very awkward. And so the sooner that St. Vincent and Grenadines, St. Kitts and Nevis, Antigua and Barbuda, and Grenada can delink from the Privy Council and accede to the appellate jurisdiction of the CCJ, then the better I think it would be.
Then we have one consistent form of
one consistent yes.
form. Yeah. But how do we prepare, say for example, St. Lucia, who has just come on board, how do we prepare them to move from what they were practicing previously to Law Caribbean Court of Justice style?
Right. They had, under the chairmanship actually of Sir Dennis Byron, my predecessor, a committee that had been charged to have town hall meetings and panel discussions and so on to help to explain the difference in regime now that the country has acceded to the CCJ. And that is something which, you know, is a model that should be followed in other countries that are thinking of making that move to the CCJ. I know in Jamaica, there's now a very lively debate on the issue because, of course, Jamaica is heavily invested, all Jamaicans, most Jamaicans, heavily invested in becoming a republic. In the nations of the Caribbean, we are all very proud people, but none more so than Jamaica. And in this day and age, Queen Elizabeth, God rest her soul, having passed on, there is renewed and intensified clamor for that country to become a republic. In this day and age, it really is an absurdity that the titular head of your country, the person who is the most senior executive authority in the country, is the King of England. That don't make any sense in 2023. And so the Privy Council is actually the King's Privy Council. So it is a bit of an anomaly to want to become a republic and still retain the monarch's privy council as your final court of appeal when there is a suitable alternative that you have paid money to establish and that is working, according to many people, just fine. And so there is a very vigorous debate being carried on now in Jamaica, not only about republicanism, but also about acceding to this.
You made me think of another issue as you made the point of the Privy Council being the King's Privy Council. We also have King's Councils who were previously Queen's Councils. What is your opinion on continuing with that sort of designation?
Well, that goes hand in hand with the Republican status. First of all, I think that there is merit. Personally, I think that there is merit in identifying senior practitioners who can be easily identified as role models, who have distinguished themselves in the practice of law and who are recognized and appreciated for their work and their expertise, their skills. So what you call them, that's a secondary issue. Now that recognition is done through a procedure where the in those countries that still retain the monarchy, where they are called Queen's Council or King's Council, depending on who is the monarch at the time. Of course, in Trinidad, and Guyana, which have been republics for some time, they're simply called Senior Council. It's simply a name change, but sorry, the underlying substance is something which I support, which I agree with. But certainly, having the name of King's Council, Queen's Council, depending on who the monarch is, because you happen to be your system happens to be one that still retains the monarchy, is just as ridiculous as continuing with the King of England being your king.
You are the president of the Caribbean Court of Justice, and I think most of us just think of you as the senior judge, but you're actually the CEO of an organization. What's the extent of your responsibilities?
Yeah, that's a good question. Because instinctively, people think of the president of the court as, well, the most senior judge, but the truth is that, as you correctly put it, you are also the most senior administrative official in the court. And even if you have a human resource expert or two on the court, a security expert as your security manager, an IT manager, a financial manager, the buck still stops by you. And you have to take an interest, at least an interest, in what these managers are doing, what decisions they are making. There are some decisions they don't feel comfortable making unless they first consult with you. And so
you're still the judge. You're still the judge.
Well, a different kind of judge. A judge in expertise that you were not particularly trained for. So the truth of the matter is that administrative work consumes maybe 40 or 50% of your time. That is also the case of a Chief Justice, by the way, because you do have to become involved in these areas of administration. It allows you to learn a lot, but I have learned a whole lot. It also requires you to adopt human resource practices that would allow the organization to be at its most efficient. But it is very taxing, and it certainly tracks from your adjudicative work. The point is that the administrative work, the non-judicial work, is of equal value to the integrity of the court, to the independence of the court, to the progress of the court, as the judicial work. And you cannot afford to ignore it. You cannot afford simply to say that, well, you have an IT manager, so all the issues in IT, let him deal with it. Or you have an HR officer, so all the issues in HR, let her deal with it. You can't afford to do that, because those decisions have a huge impact ultimately on the integrity of the court, the reputation of the court, and could even impact the decision making of the court, because the supports that are required for the decision making, if they become compromised, then it would also begin to affect the decision making itself.
You made the point that you had not been trained for the administrative aspect of your job. So how did you prepare to take on that role?
Well, for the CCJ, I was better trained than I was as acting Chief Justice of the OECS, because I had a year, almost a year, acting as Chief Justice of the Eastern Caribbean before going to the CCJ. And then during the 2005 to 2018, 13 years that I was a judge of the CCJ before I became the president, I had very, very close relationships with first President Labastide and then secondly President Byron, so that by the time I became president, I was very au fait with the kinds of decisions that would be coming across my desk, with the processes involved, with the personnel involved, with a lot of the things which were needed to prepare me adequately for my position as president. So I wasn't as badly off as some others might be. But to answer your question on a theoretical basis, I think what is required is, first of all, to listen carefully to the experts, to interrogate them very, very closely on pros and cons of any decisions which need to be made, to bear in mind how those decisions are going to impact on the court, on its stakeholders, before you give the sign off on them. But it certainly takes up a lot of your time.
You are the longest serving judge on the court and the third president. How is your tenure different from that of your predecessors?
Well, like everything else, the court is dynamic. It changes over time in terms of its priorities, in terms of its capacity, its abilities. I think that we, at this point in time, I know that we are a lot better resourced from the standpoint of our human resources than we were in the past. And not just warm bodies, but in terms of the knowledge and experience and outlook that infuses those warm bodies. And so we are able to do a lot more than we were doing before. I think that we also are in a position now where 18 years on, the external environment has changed considerably. In 2005, when we went down to Trinidad, the environment was not very welcoming. People either didn't know anything about the court or were indifferent towards the court, some even hostile. Now you have passionate advocates for the court. Every week you read an article in the newspaper that is very complimentary of the court, is pressing for the government to accede to the court. So it's a different environment in Trinidad and in the region, and one that allows us to do a lot more. And we're trying to, exploit that situation as best we can. Some of these things have nothing to do with me or with my leadership. I don't take any credit for it. It's just the way that life has proceeded. But I think that we are really poised to make a greater impact on Caribbean civilization. I think that St. Lucia's accession has again jolted countries into the recognition that, look, this is something that you need to put on the front burner. I'm hoping that in my own country that there will be a recognition that acceding to the court is the right thing to do, and that responsible leaders need to take that decision. Because if you don't, then you are going to be denying the opportunity for justice at the apex level for, albeit few Vincentians that need that justice. I could very well see that there would be instances where a person who is dissatisfied with the decision of the Court of Appeal and wants to appeal now is frustrated in their ability to appeal because of the sheer expense and the uncertainty. It's not just the expense, it's the uncertainty when you couple those things. Because if you know that you spend this money and you're going to win, then that's one thing. But litigation is always uncertain. So what is looming before you is to spend 15, 20, 30,000 pounds or more. And you don't know whether after spending that, you are going to be satisfied. And so you are then deterred from taking that step. On the other hand, if there were a CCJ, the most you'll be spending in filing fees is $1,200, $1,500 US. And even though for a poor person, that is, a bit of money, nevertheless, at least it's not a sum that will wipe you out. So that if you lose, then you're not wiped out, But I don't know. I really do think, and I make this appeal to all patriotic Vincentians, that the current situation where litigants are denied effectively a third tier in the justice system is really untenable.
This brings me to your checklist. Earlier on in your tenure, you had a checklist of things, I guess, from your own strategic plan of objectives that you wanted to achieve. How would you judge yourself on the progress of your checklist?
I think we've done pretty well in almost all areas. There is still an area which each time we speak with our stakeholders, they tell us we need to do better. And that is honing our public outreach. Of course, you don't have unlimited funds. And so we have to maximize the use of our funds. We had a group of lawyers who were all called to the bar, or who all graduated UE at the same time 25 years ago. And they were saying to us that they were making suggestions as to how we could be more effective at informing the public about our judgments and about what we do. But part of our problem has been that a delicate balance has to be struck between legitimate provision of information on the one hand and coming across as proselytizing or selling yourself. In the early years, we went throughout the region having town hall meetings and so on. And in Grenada, a man accused us of, you guys are salespersons, you're selling yourself and you're supposed to be judges. And it stopped us in our tracks. And we kind of took a step back after that, because it's true, judges are everywhere in the world. You're born, you grow up, you meet the court. The court is there. Nobody has to sell the court. Nobody has to persuade you that the court is worthy, that you need to embrace the court. The court is there, it's a fact of life.
But is there not an alternative argument to that, in that this is new? In the early days, the Caribbean Court of Justice had no predecessor. So yes, it had to be sold. Who was going to sell it more than the judges who were going to be functioning in the court?
Well, that's the issue. You see, there's a feeling, and there's some basis, there's a good basis for that feeling, that judges are judges, not salespeople. That the integrity, the demeanor, the status of judges are such that they ought not to descend to the level of being salespersons for a court that they preside over. And there's some merit, there's a lot of merit in that argument. But who's going to do it if the court doesn't do it? CARICOM has other priorities, the CARICOM Secretariat. Once the court was set up, that work ceased. Before the court was established, CARICOM did a lot of work up and down the region to inform people about the court, to sell the court. And then after the court was established, they pulled back. And one could understand that. I'm not knocking them at all, because they have scarce resources, and okay, the court is up and running now. The court must demonstrate and show its prowess, and that's fine. But there isn't anybody else that does that kind of work. So we have to get our public communications department to be very effective in not putting the judges out there as salespersons, but at the same time finding the best ways of conveying to the public what we do and trying to get them to have a better understanding of the court and what is happening at the court.
So generally, a really good passback.
I would say that. But I'm biased. You need to tell me. Actually, we have empirical evidence, because what we have been doing is trying to get precisely that kind of information from our stakeholders. And a couple of months ago, we did a survey of lawyers who had appeared before the court, litigants who had appeared before the court, and so on. And it's still being packaged to be published, but it will be very soon. And generally, the response has been great. And in fact, over the last couple of months, weeks, I've been seeing this in the Nation newspaper. Just within the last week, there was a very glowing tribute to the work that the court has been doing. Increasingly you see articles of that nature popping up in newspapers around the region. So I think that we are on a good track.
Well, congratulations. I know you're humble and you're saying that's not all due to you, but certainly it's something to be proud of.
Thank you. Thank you.